Thank you, David. Now, a slightly more complicated one, but pressing, because on the 31st of December, as we have heard, the PLR directive is going to be enacted in Italy, or if they manage, but the intention is there, which means on the 1st of January next year, all vessels will have to have on board a certificate issued by the flag state in a similar fashion as we do for CLC, as we do for bunkers and so on, i.e. backed by a club or an insurer's blue card provided to the flag state, for the flag state to issue their own certification. Okay, here we're working a lot to try to speed up the process of issuing certifications. It's the constant fight on electronic documentation being accepted as against originals and so on. It's a battle which we are winning, and with the help of Confitarma, and that is something which is going to be on the table tomorrow, again, on the thing we are going to discuss. In any event, what is important is, insofar as the other conventions, blue cards are normally being issued by the clubs, satisfying the scope of certification for the individual conventions. In respect of the PLR, which actually, by way of law, introduces Athens Convention, the Protocol 2002, even if the protocol itself has not is not in force yet, because the necessary number of states has not ratified it. But by way of the EU directive, basically, it will go back through the back door and it will become enacted in a way by way of enactment in the European law. This will give rise to the necessity of furnishing ships with evidence of insurance in the form of a certificate issued by the flag state, as we do, as I was saying before, for bunker and CLCs. That, of course, implies the insurer of the ship, typically the P&I clubs, to issue blue cards. Here we have a little bit of a problem, because whilst the clubs have accepted that they will be providing the blue card in respect of ordinary risks, we have an issue because Athens Convention and the protocol, despite all the fights which have been fought over the years, provides that the ship owner needs to be insured for his liability to passengers, also in respect of war and terrorism risks, risks which are not covered by the standard P&I club. Cover, sorry. sorry, Jamie. By the standard P&I cover, okay. Lapsus, because he's from the standard club. And so we are now a few months away from the thing becoming live, and we still have a few uncertainties on how the thing of issuance of blue cards will be dealt with. For this reason, we have Jeremy Grose, who is the CEO of the Standard Club, and he's going to tell us where are we on blue cards for passengers' liabilities. Thank you, Jeremy.
Slides, and it's a good job, because if I had, Federico would have just explained to you everything that was on them in the first place. But I just wanted to spend a few moments, Professor Berlingeri has given you an introduction to the EU passenger liability regulations, but I would like to spend a few moments explaining what the regulation requirements are, what their implications are with respect to evidencing insurance, and what are the remaining unresolved complications and how those might be solved, as Federico was saying. First of all, the legislation or the regulation provides that the carrier, a passenger ship operator, will be strictly liable to pay compensation for the loss suffered as a result of the death or personal injury to a passenger caused by a shipping incident up to a value of 250,000 SDRs. That's about $387,000 per passenger. If the loss or damage exceeds 250,000 SDRs, the ship owner will be liable up to 400,000 SDRs, which is about $620,000, unless the carrier proves that he was not at fault. And if there is an incident which is not a shipping incident, such as a fire on board the ship, the carrier is liable up to the higher limit of 400,000 SDRs if the claimant can prove fault or negligence on the part of the carrier. So the liability regime is immense. It's a very significant development. You can obviously do the maths for yourself, but a passenger ship with 1,000 passengers on board would have a strict liability under this regulation of somewhere in the region of $387 million. It comes into force at the end of this year, on the 31st of December, and from that date, passenger ships registered in or trading to EU or EEA member states will be required to have insurance in place or some other form of financial security to cover liabilities up to 250,000 SDRs per passenger. The regulation, like the Athens Convention, excludes war, but the ship owner is still liable for some acts of terrorism if they are partially at fault, say, for instance, if they were partially to blame through having had a breakdown in their shipboard security system, or if they had negligently employed a member of the crew who subsequently carried out the terrorist act, and there was some negligence found on the part of the ship owner. That element of war and terrorism risk remains in the regulations, and from the outset of the discussions about Athens, which the PLR, as I say, closely mirrors, the clubs have expressed reservations about their ability to be able to issue blue cards in respect of the ship owner's potential liability for terrorist acts. And after extensive discussions, the IMO guidelines issued in 2006 made provision for two separate blue cards, one for non-war risks and another one for war risks. This is an unusual development. The guidelines also put a cap on the liability in respect of terrorist risks of 340 million SDRs, which is still around about $523 million. The EU or EEA member state will issue one PLR state certificate when they receive a blue card for the war risks and a blue card for the non-war risks from the insurer or financial guarantor. As has been said previously, following consideration by the boards of the clubs in the international group, it has been agreed that clubs will be able to issue the non-war blue cards and treat any liability arising as a consequence of having issued a blue card in this respect as being poolable, and will therefore be able to take advantage of the group's reinsurance arrangements up to $2 billion. It's in respect of the war risk blue card that the complication arises. At the moment, clubs are not the primary insurers of war risks, of P&I war risks. The risk is normally insured as and is included with the owner's hull and machinery policy. The clubs are therefore not the insurers of the primary insurers of the risk which is requiring to be certified under the blue card, or the war blue card. And following a period of discussion this year, where we have been discussing with boards the possibility of reconfiguring cover so that the group, international group, reinsurance arrangements were reconfigured and the underlying cover of clubs was reconfigured so that we became the primary P&I insurers. That remains the case, and we are still not the primary insurers. A majority of clubs was not in favour of changing the way in which the cover is configured, and as a consequence, any club that wished to issue a war blue card on behalf of any member entered would not be able to use the reinsurance arrangements of the international group, the group pooling arrangements that we have, and the cover up to $2 billion. I would say that personally, I think this was the wrong decision. I think this is a poor development for the international group clubs. It's been a feature of clubs that we adapt to the requirements of ship owners as those requirements change. And I regret the fact that clubs did not agree to change the way in which cover was configured. And it's a poor state of affairs. If a club like ourselves, like the Standard Club, were still to wish to issue a blue card, we probably could, well, we could, in fact, but we would need to make ourselves, we would need to have some reinsurance outside the international group, pooling arrangements, a separate non-poolable cover. And the problem is, with the limits that are available, the limits that this regulation provides and the way in which the war risks reinsurance market is configured, it would not be cost effective for clubs individually to go out and buy reinsurance cover. So it looks likely that the provision of war blue cards in respect to the PLR is going to be provided by one or two commercial guarantors. One of them is a Norwegian operation called Safeguard, and the other is a UK outfit which is backed by Lloyd's Market Insurers. And they have sufficiently gathered together enough of the market to provide for what it may appear to be a cost-effective way of providing for this cover. We, as the Standard Club, are continuing to work with them and with the guarantors or the reinsurers of these guarantors so that we can take advantage of the bulk purchasing of the way in which the market is being put together, so that we may be able to issue the blue card in the first place. But I'm in the unusual position, I'm afraid, of encouraging Mr. Diodato, when he goes to see CONSAP tomorrow, to encourage them to prepare themselves to accept a blue card in respect of liability insurance not from a club, but from a commercial guarantor, because that's the only way, it seems, that in many, many respects, ship owners will be able to satisfy the requirements of the passenger liability regulation and have both a non-war blue card, which will be issued by the clubs, and a war blue card, which currently it certainly won't be issued by many of the clubs. It may possibly be issued by some clubs, but the primary providers of these war blue cards will be the commercial guarantors. Thank you.